Accordingly, this writ petition is disposed of with a direction to the respondents to look into the grievances projected by the petitioners in terms of the representation submitted on so and so. Liberty is also given to the petitioners to submit any other additional documents which justify their claim to the respondent authorities. Such consideration should be done by the respondent authorities, if necessary, by constituting an expert body/committee, and the consideration should be concluded by passing a reasoned and speaking order within a period of 4 months from the date of receipt of a certified copy of this order. Yes.
May I please? I beg to mention item number 28, my lord, of today's list, my lord. I am led by Mr. Das, my lord, who is indisposed today, my lord. Can
BC
it be
Das.
heard? Mr. BC Das.
Hmm.
Can it be heard on 7th, my lord? January 7th.
All right. Mr. BC Das, learned counsel for the petitioner, is said to be indisposed. On a mention made on his behalf, matter stands adjourned to be listed again on 7th of January 2025 for hearing.
Obliged.
May I please, your lordship?
Hmm.
My lord, I have prayer for listing of a case, my lord, in the month of next January, my lord, 2025. Matter pertains to my lord selection and appointment to the post of constable, my lord.
Hmm.
Lordship will kindly fix it at 7th of my lord January 2025.
For what? For admission?
Admission.
Admission hearing or
Admission, my lord. Then here, admission. Needs to be disposed of, my lord.
the pleadings are complete?
Pleadings are
All right. All right.
7th of January.
Yes.
May I please, your lordship. This contempt petition, my lord, notice was issued, my lord, despite my lord returnable date is over, my lord, it's not being stayed, my lord. May I pray may be taken up on Monday, my lord. It's against a held up of salary, my lord, with a direction to pay within 3 months. That has been violated.
All right.
Deeply obliged, lord.
Lordship, item number 25 and 26. Here I am appearing for the review petition on state government. Lordship, I am praying for taking up this matter after review petition. The other side is also present.
There will be, my lord, on 28th of January, my lord.
You agreed? 28?
28th.
All right. As prayed for by parties, list the matter on 28th of January 2025 for hearing. Item 25 and 26. Yes.
May it please your lordship.
Hmm.
Item number 13 to 15, it's a part-heard matter. So it has been wrongly listed as shown in the supplementary list also,
In my copy, it is blank. I don't know why it is blank.
because in the,
Records are not here. Okay. There are no records
yes,
here.
Your Lordship,
Oh.
because in the supplementary, there is a note that it has been wrongly listed.
Hmm.
It was
Okay.
part heard by.
May it please your lordship. May it please your lordship. With the consent of other side, I beg to mention item number 22, lordship.
You gave the adjournment slip.
Lordship,
You're for the petitioner.
lordship, yeah, I'm
When,
for the-
when do you want it?
after 2 weeks, lordship, after.
You're for, okay. As paid for by the learned counsel for the petitioner. Matter stands adjourned for 2 weeks. Yes.
Deeply obliged.
May it please your lordship. Lordship, I beg to mention item number 27 of today's list, lordship. Hearing.
Yes, what do you want?
So I want adjournment, lordship. It may come after the vacation, lordship.
As paid for by the learned counsel for the petitioner. You're for the petitioner.
Petitioner, lordship.
Matter stands adjourned. Matter stands
Lordship,
adjourned.
date may be fixed since it is a service.
Will be listed again after the ensuing vacation. On 21st,
Oblige,
21st of January, 2025.
oblige.
Yes.
May I please, your lordship. May I please, your lordship. Lordship, I'm paying for listing of a writ petition, my lord, for motion, my lord, on 18th of this month, my lord. A similar matter are also listed on 18th, my lord.
Yes.
My lord, I'm obliged.
May it please your lordship. Madam, item number 12, madam.
Hmm.
Can it be adjourned for 10 days, madam?
Why?
In this case, madam, the learned advocate general is appearing. He is not present, madam.
Who's for the other side?
Madam, I've taken
Mr. Manta is there?
I've taken the consent, madam.
Appearing for the petitioner lordship.
Okay.
Next lordship.
After vacation.
As their wish, madam.
10 days means after vacation.
No, 10 days will be it will 20. It will be at 21, madam.
Last day.
Last year.
What will happen? on this?
No, I have no objection, my lord, but we have some urgency. But anyway, my lord, like 2021, my lord.
21 is Saturday. Mistake.
20 is the last date.
20 is Saturday.
No, not this one, this month,
Oh, next January.
after this one. Because from, I think from 12, it is again, it is a holiday.
Okay.
7 days.
On 21, then hearing date. As paid for by Mr.
SP Das.
SP Das, learned counsel appearing for the
Number 6, 7 and 8, madam.
respondent number 6, 7, and 8, and not objected to by the other side. List the matter. On 21st of January, 2025.
Leave Gabla.
Yes.
May I please, lordship. Item number 9 and 10, lordship, may be
Hmm.
taken after vacation, lordship.
Why?
Lordship, the other side has not filed evidence in opposition, lordship. And in the meantime, we are to implement some respondent, lordship.
You're for the petitioner.
Lordship.
On the prayer of learned counsel for the petitioner / petitioners. Matter stands adjourned to be listed again after the ensuing vacation. Liberty is granted to the petitioners to file impleadment application for impleading
Respondent.
new respondents, if so advised. As paid for, add that, as paid for, yes.
I appear for respond numbers 1 and 5.
Mr. D. Bora, learned
Number 9.
learned government advocate, appears for respondent numbers.
1 and 5 in item number 9 and respond number 3 in item number 10.
It's okay, appears for state respondents. And praise that. No. That's okay. Appears for the state respondents. That'll do.
Yes, please, lordship. Lordship, I beg to mention item number 24, lordship. I am on behalf of Mr. A.K. Progester, lordship. Lordship,
24.
24, lordship. Lordship, if possible, matter may be list after vacation, lordship.
As paid for by learned counsel on behalf of Mr. A.K. Prokastha, who represents the petitioners. List the matter again after the ensuing vacation. All right.
Obliged, Lordship.
May I please your lordship, I beg to mention one WBC for orders. At the time of filing of the writ petition, inadvertently, I have not made party of the France agency who funded the Assam Forest and Biodiversity. And I have released from service and I was worked as a senior procurement specialist. So for orders, my lord, may take this matter on, listing this matter on 16th of December.
Why for orders? If you have
He has
forgot,
been- he has terminated-
see, if you have not impleted the party concerned, you file IA to implement.
Yes, I have filed IA, my lord, for which I want time. I have already filed
When
IA,
did you file the IA?
filed 1 week ago.
When did you file the IA?
I was filed, I was filed about 1 week ago, my lord. I filed the IA, so my lord may take the matter. for-
Serial number? Filing number? You don't have.
I have, my lord. I will.
You have a mentioned memo with you?
Yes, I will collect the filing number.
What is the case number?
I have the WBC number, my lord, 3573.
Oh, this will come up in after winter vacation.
Yes, for orders, my lord.
Exactly. You'll come on 8th of January.
Obliged.
All right.
May it please, your lordship. Your lordship, my line of argument was on a very narrow compass, your lordship. The issue which my learned friend had actually raised with regards to the validity, the statutory force of a policy, transfer policy, I'm not under issue at all, your lordship. I'm simply on the issue of frequent transfer, not substantiated by reasons. And that, your lordship, has been stated clearly in the judgment which I had actually placed before your lordship in the case of B. Varada Rao versus State of Karnataka. In that judgment, if I may take your lordship again to the.
See, Mr. D. Bora, we have heard parties at length yesterday.
Yes, your lordship.
Basically, it's a motion hearing.
Yes.
I don't think you should open up again. I've understood the case.
Yes, sir.
Now, what we can do is we can issue notice. You can go and join your place of posting.
Your lordship,
And you have filed some representation or something like that. So that will be decided on its own merit by the authority concerned.
no, your lordship, why I lay stress on one particular point, your lordship. This particular post.
No, wait, just a minute, Mr. Bora, let me complete.
Yes, sir.
So that is one option. We issue notice and there will be no interim order. Your representation will be considered by the authority concerned within a time frame. The second option is we dispose of the writ petition itself. And keeping in view that you have submitted some representation, which should be decided in its own merit. And no point keeping the matter pending here.
Your lordship,
But there'll be no stay.
your lordship, with regards to second, why I'm paying your lordship for a stay of this impugned order. The present place of posting is a command tenure. Now, as stated in my writ petition itself, the next promotion post of superintending engineer, the recruitment rule says so that I should have minimum 2 years of command experience.
See,
That I stated in my writ petition.
so if
Now,
you want,
If
no,
I
you-
transferred from this particular present post of posting to Isol,
Hmm.
which is not a command tenure.
Hmm.
I have been transferred to the chief engineer's office.
Hmm.
That is not a command experience.
Hmm.
Your Lordship. Then my promotion chances will be hampered. In that respect, your lordship, if I may place just one judgment, your lordship, just one judgment. Wherein
No.
my learned friend, where he has stated that statutory force, this policy guidelines have no statutory force. Yes, I completely bow down before the Honorable Supreme Court guidelines, judgment in SL Abbas as well as SC Saxena. Your lordship, I'm not on that issue at all. I'm simply on the issue of
Frequent transfer. I've
not
understood.
Substantiated on the basis of reasons.
That's why they will consider this aspect on the basis of its own merit.
Your
We
lordship,
don't sit here as an appeal on the decision of transfer.
I agree, your lordship.
That transfer should have been done this manner or that manner. That we are not saying.
Yes, your lordship. Just that till this representation is disposed of, I may not be in trouble.
No, that cannot be.
Your lordship, that is why, because my career chances will be.
That cannot be.
Because if I may place just one.
We'll make an
judgment,
observation that your representation will be considered in its own merit. And
Lordship.
it is the fact that you have joined the place of posting should not deter the authorities from taking a
Your lordship, my career progression. will be
reconsideration.
happening.
I
Will
understand.
not be considered for promotion to the next high post of superintendent engineer. Because I'll not have command experience. I have stated so. Let them reply to that particular fact in my
See,
repetition.
you are talking about frequent transfer. Who knows? Within the next 2 months, again, you'll be transferred to your
Lordship,
command
that is
posting.
what-
We don't know.
That is what your lordship.
So we cannot go on presumption that this will not happen or that will not happen.
Your lordship,
Everybody
Supreme Court
goes
has
for
said-
their own promotional aspect. You join a post thinking that you will move ahead in your career.
Pardon, your lordship.
Everybody does that.
Supreme Court has said, your lordship, frequent transfers without sufficient reasons to justify such transfers cannot be but held as mala fide, your lordship.
We'll put that on record also if you
Your
want to.
lordship, this particular, I'll be, if I am transferred, your lordship, I'll lose my promotional avenue. Lordship, may kindly take note of that particular fact. I have pleaded, I have made a specific pleading to that
So,
particular effect.
okay, we'll make an observation to that effect also and say that this presentation should be considered in its own merit by taking into account the fact that the petitioner would chance to lose the opportunity of further promotion if he is not posted in a command post. That observation we can make.
That observation will not.
I've given you two choices. You want it to be pending
negate
or you want it
your-
to be disposed. You take your
Your
call.
lordship, that will not negate my whole writ petition, your lordship. If today this particular frequent transfer, in one calendar year, I've been transferred twice. First 2 months, then 5 months, your lordship. And
We'll,
there are
we'll,
judgments
we'll,
which-
we'll record all that. That will be a good ground for them to consider.
Correct, your lordship. And the Honorable Supreme Court has said, frequent transfer without sufficient reasons as such is held considered to be mala fide. In the impugned order, there is no such reason as such, except for the word organizational interest, which the Honorable Supreme Court has said. If I may place just one judgment, your lordship, then your lordship may, I think, your lordship may kindly, please to change the point of view of this Honorable Court, your lordship. Just if I may place this judgment, your lordship, just one line, your lordship, just one line, your lordship. It's a citation is 2010 2 GLT 786. And if I may take your lordship. To paragraph number 21.
Yes.
The learned counsel for the respondents referring to the decision reporting in VP versus Govardhan Lal submitted that transfer orders should normally be issued and should not be interfered with by the courts, and the allegations of malafide such as must be such which inspires confidence. The relevant extract of the decision referred to above may be gainfully reproduced below. It is too late in the day for any government servant to contend that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in the terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary. In the law governing our conditions of service, unless the order of transfer is shown to be an outcome of a mala fide excess of power, violative of any statutory provision, an act or rule, or passed by an authority and are competent to do so, an order of transfer cannot lightly be interfered with as a matter of course. For routine, for any or every type of grievance ought to be made. Even administrative guidelines for regulating transfers or continued transfer policy at best may afford an opportunity to the officer or servant concerned to approach the higher authorities for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer servant to any place of in public interest, and as is found necessitated by exigencies of service, as long as the official status is not affected adversely and there is no infraction of any career prospects such as seniority, scale of pay, and secured emoluments. This court has often reiterated that the order of transfer made even in transgression of administrative guidelines cannot also be interfered with, as they do not confer any legally enforceable rights unless, Your Lordship, I lay stress on this, unless as notice supra shown to be vitiated by mala fides or is in made of any violation of any statutory rules. Now, if I may take your lordship to the next page number, paragraph number 23, your lordship. Even though the guidelines issued by the government is considered to have no statutory force in view of the decision referred in Kalyan Kumar Sarkar's case, however, the petitioner has been able to establish that he was transferred from the present place of posting only to accommodate the respondent number 5 who was holding the same post prior to the transfer. Over and above, the state respondents did not file any affidavit to show the extent of public interest involved and or the exigency of public service in transferring respondent number 5 immediately within 6 months to the same place where he was previously posted. The above exercise on the part of the state respondents, apparently not in the interest of public service, obviously would only to serve the political or personal interests of some individuals as reflected in the relevant file of the department. This is what is apparently an arbitrary exercise of jurisdiction, which cannot be given a stamp of approval of this court. Here, my case is squarely covered by this judgment, your lordship. Let them file an affidavit, let them produce the records. What is the difficulty? Just by citing organizational interest will not suffice, your lordship. My career prospects will be hampered, your lordship. The statutory rules says so, the recruitment rules say so that I should have minimum 2 years of command experience, and this was the best possible available because I am 54 years old, your lordship. Next year, I'll be considered for promotion to the rank of superintending engineer. Now, if I am posted out, your lordship, next year, I will not be eligible for consideration for the post of superintending engineer because I don't have command experience. Let me complete the 10 years. And because this, I have been given this tenure, your lordship, after meeting the respondent number 2, I have annexed that particular letter also, where I have been given opportunity to meet the respondent number 2, that is the DGBR, Director General of Border Roads, where I have been given this command posting after meeting with the Director General, with the assurance that yes, I will not be disturbed. That is the ground, your lordship.
You have forwarded your representation?
Your lordship, I have not forwarded representation.
You have not,
I have
you have not
annexed
submitted your representation.
I have submitted on Monday, your lordship.
Monday, to whom?
Monday, your lordship.
To whom?
To the DGBR, your lordship.
DGBR.
That is the issue. Let them produce the records, your lordship. If this is not state, your lordship, my career progression will be hampered. If I join there, everything will go. I will not be promoted, your lordship. Next promotion post is superintendent engineer. If tomorrow I join there, your lordship, my reliever has not come. If I join there, I'll lose that particular command experience. I'll not be eligible. The recruitment rules say so.
But the law is also very clear, you see.
Yes, your lordship. The law
Supreme
is
Court has laid down that you cannot, reject the transfer orders just like that and come to the court.
yes, your
The
lordship.
judgment.
This is also Supreme Court VP versus Governor Land. The Supreme Court has said so. If and only if the career prospects are hampered, your lordship. This is Supreme Court also said that.
SC Saxena's case.
Yes, your lordship. SC section, I'm not on that I'm not on that particular line of thought, your lordship. That is not my line of argument. I'm not on the line of argument that guidelines have a statutory force. This guidelines are enforceable and I have a enforceable right to be before your lordship.
No, I'm not on the guidelines. If you read paragraph 6 of the judgment,
Yes,
it speaks for itself.
your lordship, what I'm trying to distinguish from the facts of SC Saxena, because the SC Saxena was not in relation to frequent transfer, your lordship. SC Saxena was a different issue altogether. It was relying on whether this policy guidelines has got an enforceable and any enforceability in eyes of law, and whether this court, Honorable Court under Article 226, has got the power. Because I am only on the ground of reasonableness, your lordship. And Article 14 strikes at the heart of arbitrariness, your lordship.
All right.
This particular order as such is totally arbitrary. Simply by citing organizational interest will not do, your lordship. This will set a very bad precedent. Tomorrow, everybody will be transferred on 2-3 months, and then they will say organizational interest, your lordship. Let this honorable court examine, your lordship. Let the records be produced. Let the reasons be shown as to what made them transfer me before the completion of my command tenure, your lordship.
In that case, we'll issue notice but no stay.
Your lordship, that is the difficulty, your lordship. If it is not state, then the whole matter would become infructuous. I have to join them. Otherwise, they will
Yes.
take disciplinary proceeding against me.
You'll have to join. What to do?
Your lordship, I'll be highly prejudiced, your lordship. I'll be highly prejudiced.
That's all.
Your lordship, that is my humble.
You want me to dispose it or you want me to just issue notice?
Your
Which one?
lordship, may kindly let them dispose, because the guidelines say so that if I submit a representation, they have
That will be there.
they will
This way or that way,
One
we'll ask them to dispose it off, but there'll be no stay.
they are bound to dispose it within 1 week. The guidelines say so. If I may take your lordship to the guidelines, your lordship, then their own guidelines say so. If I submit a representation, they will dispose it up at page number 33, your lordship, 34, your lordship. Till the representation is disposed of, your lordship, I should not be disturbed. your
So
lordship.
you have not even mentioned about your representation in your writ petition.
Because of the paucity of time, your lordship, I was not even allowed to go on leave, your lordship. So as to come to Guwahati and file this writ petition. I had this particular writ petition notarized in Along. I could not leave my station. They knew very well, your lordship. For the paucity of time, your lordship, they issued this order on 6th. I
Your-
was handed over on Saturday, 7th.
Your annexure 8 is also wrongly typed. Annexure 8, page
Annexure-
27.
Annexure 11, your lordship. page
Annexure 8.
That's a impugn.
Your name is what? Chandrasekhar Balachandran.
Bela Chandan.
Bela Chandran. What have you typed in page 27?
Your lordship, that's a typographical mistake.
That's what I'm saying.
But I am only on the ground of representation, your lordship.
Anyway,
Let them dispose of the representation within 1 week. Until then, I should not be disturbed, your
there'll
lordship.
be no till then. I'm sorry,
Your
Mr.
lordship,
Dibora.
that is the difficulty, your lordship. I'll be highly.
What to
prejudiced,
do?
your
You,
lordship. And my deliver will come by joining by tomorrow, your lordship. I'll lose out on my career prospects, your lordship. Career advancement will be hampered,
Mm.
your lordship.
you have taken note of that already. Heard Mr. D. Bora, learned counsel for the petitioner, and Mr. K. Gogoi, learned CGC for the respondents. By having regard, I'm disposing of having regard to the nature of grievance projected by the petitioner. The writ petition is taken up for final disposal at the motion stage itself.
The post where he was transferred for project Puspok Aizol Losik, this post was vacant post Losik. And the persons who was posted to Brahman, he already relieved Losik.
Your lordship,
Uh,
if my career is hampered, your lordship, it will be a sort of a punitive order, your lordship. My career will be hampered, your lordship.
You let me pass the order, Mr. Counsel. I've heard you. I've heard the other side also. What did I say? Itself. Stop, next para. By filing this writ petition, the petitioner has challenged the transfer order dated 6/12/2024, by which he has been transferred from 92 RCC/44 TF/BMK to headquarter CE bracket P PSK, and he has been directed to move forthwith. So by the same transfer order, one Dhiresh Kumar has been posted in place of the petitioner. Stop. However, Dhiresh Kumar is not a party to the instant writ petition. Next para. Assailing the transfer order, the petitioner, through Mr. D. Bora, learned counsel, contends that the petitioner had joined headquarter CE bracket P Brahmak on 13/2/2024 bracket FN. As can be seen from the arrival report of the gref officer bracket annexure 1. Stop. Thereafter, within a period of about 2 months, the petitioner has been transferred to 92 RCC slash 44 TF slash BMK, and he has been directed to move by 9/5/2024. That order date, 8, what did I say, 8 April, no? Did I say 8 April? No. Write the order of transfer dated 8/4/2024, bracket annexure 2. Stop. As such, a movement order was issued on 27/4/2024, indicating the date of departure of the petitioner to the new place of posting as 30/4/2024, bracket FN. So accordingly, the petitioner joined the new place of posting on 9/5/2024.
Your Lordship, the movement order is annexed, the fresh movement order is at page number 24, annexure 6, 8 May. On that basis, I joined on 9th May.
What about this?
It was modified. After that, April 1, I met with the DGPR. That is, I've been
Okay.
annexed.
Accordingly, I
page
said, no?
22.
From accordingly, you cancel. The petitioner, why did you meet the DGPR?
Because of this command tenure, Your Lordship. I was granted this command tenure. I accepted it.
No, you were transferred by this order.
Yes, 8/4.
So you joined that place, isn't it?
Yes.
Then
Only
what
after
was-
the assurance given by the DGPR that I'll not be disturbed from this particular place. Because it's a command tenure, Your Lordship. I was given assurance that.
Command
DGPR
tenure in what? 92 RCC?
92 RCC. It's a RCC, Road Construction Company, executive tenure.
You are transferred there.
Yes.
You went to the DGPR just to get the assurance that you will not
No,
be
no, no.
transferred.
I actually thought, why are you transferring me within 2 months? That's why he assured me that, no, I'm transferring you because you are getting this command tenure. That's why I accepted this. I accepted this posting at 92 RCC. I don't have any qualms
The
about it.
petitioner, in view of his transfer within a short period of time, met the Director General of Border Roads,
Respond number 2.
bracket respondent number 2,
On 1st May.
on 1/5/2024. And according to the petitioner, he was assured by the said authority that his transfer and posting to the new location would be sustained, and that he was being transferred since it was a command post. Stop. A fresh movement order was thereafter issued, and pursuant to which the petitioner joined the new place of posting on 9/5/2024, bracket forenoon, FN. Stop. Next para. However, to the great surprise of the petitioner, white posting order dated 6/12/2024, he has been posted out from 92 RCC/44 TF/BMK to headquarter CE bracket P PSK.
Pushpak.
These are all in abbreviation. I'll use that only.
Yes, Your Lordship.
And he has been directed to move forthwith. Stop. Mr. D. Bora, Learned Counsel submits that despite the assurance given to him by the DGBR, he has been transferred out again. Within a period of 7 months to a new location, which is not even a command post, and which would be detrimental to the petitioner's career prospect. Stop. He submits that in order to be promoted to the next rank of superintending engineer, an officer in the rank of executive engineer is required to have command posting of at least 2 years,
Experience.
command experience of at least 2 years. And by issuance of the impugned posting order dated 6/12/2024, the petitioner will lose his chance of promotion, and that he is almost at the fag end of his career in the service. Stop. The Learned Counsel, by referring to the posting policy for gref officers, submits that executive tenures are generally to be for a period of 2 to 3 years for officers in the rank of executive engineer or equivalent and above. Stop. The same, however, can be curtailed or extended due to organizational requirements or on performance of the officer. Stop. However, in the instant case, there is, according to the petitioner, there is no issue with regard to his performance, and merely by stating that what is that word?
Organizational interest.
O- in the organizational interest that the petition has been transferred would not suffice. And therefore, the impugned transfer order has been issued in a most arbitrary manner and should be interfered with by this court. In support of his submission, the learned counsel has relied upon
B. Varadha Rao versus State of Karnataka.
the following authorities. I'll cite all of them.
No, I only cited two judgments, Your Lordship, regarding frequent transfer of the Honorable Supreme Court.
You gave me 3 judgments.
Lordship, first is B. Varadha Rao.
Let me incorporate all of them. Do you have any objection?
No.
You only cited. Why did you cite then if you
Yes.
don't want?
No.
B. Varadha Rao versus State of Karnataka and others. 1986, 4 SCC 131. Number 2. TSR Subramaniam and others versus Union of India and others. 2013, 15 SCC 732. And Sunit Kumar Bardoloy versus State of Assam and others. 2010, 2 GLT 786. Next para. Per contra, Mr. K. Gogoi, learned CGC, submits that the petitioner cannot have any grievance against his transfer to the new location. What are you saying? That vacancy?
The post is still vacant.
Which post?
That where he was posted in the Puspok as well, Lordship,
Ah.
that post is vacant post, Lordship.
So it has to be a vacant post. Otherwise, how will he go there?
That nobody was replaced from that particular post. So it's a vacant post. He was posted there. And the persons who was posted in his place, Lordship, it was from the headquarters of Greek, Lordship.
Okay.
Lordship.
Submits that the place to which the petitioner has been transferred out through the impugned transfer order is a vacant post. And he submits that the petitioner has been transferred out in the organizational interest. And that he cannot be said to have any enforceable right by relying upon the transfer policy. As held by the apex court in a catena of decisions. Stop. He submits that transfer is an incident of service and therefore executive instructions or administrative instructions concerning transfers and postings do not confer an indefeasible right to claim a transfer and posting. Stop. Individual convenience of persons who are employed in the service is subject to the overreaching needs of the administration. He further submits that no government servant can claim to remain in a particular place or in a particular post unless his appointment itself is to a specified non-transferable post. Top, he also submits that even if, even in the event the petitioner has any difficulty with the new order of posting, comma, he should first join the new place of posting and thereafter avail for any such remedy that may be available to him in law. To stop from the writ petition, the learned CG submits that it only appears that the petitioner has not even availed, have not even represented his cause to the respondent authorities concerned before approaching this court. Stop. Therefore, the petitioner cannot have any legitimate grievance and the writ petition should be dismissed. In support of his submission, the learned CGC relies upon the following authorities: SC Saxena and versus Union of India and others, 2006 9 SCC 583. Dr. Nagorao Shivaji Chavan versus Dr. Sunil Purushottam Bhamre and others, 2019 13 SCC 788. SK Nausat Raman and others versus Union of India and others, 2022 12 SCC 1. And judgment and order dated 2/12/2024 passed by a division bench of this court in WPC number 2460/2024, open bracket, Union of India and 4 others versus Sri Kundan Kumar, close bracket. Next para, I have heard the submissions made by the learned counsels for the rival parties and peruse the materials available on record, including the authorities relied upon. The projection made by the petitioner mainly is with regard to the frequent transfer given to him. Stop. As already cited in the preceding paragraph, the petitioner was transferred to headquarters CEP Brahmak, where he joined on 13/2/2024. Stop. Thereafter, he has been transferred out to 92 RCC bracket, /44 TF/BMK, White order dated 8/4/2024. Stop. It may be noted that the posting to 92 RCC /44 TF /BMK, according to the petitioner, is a command posting, and that despite the objection that was raised by him to the DGBR, he was assured by the state authority that he would be kept in the new place of posting for a reasonable period of time. And since the same is a command posting, the same would be in the interest of his service carrier. Stop. However, after the petitioner joined the said place of posting on 9/5/2024, he has been transferred out by the impugned transfer order dated 6/12/2024. Stop. The petitioner, apart from taking the plea that the same being not only a frequent transfer, but the same would be detrimental to his service carrier, has also taken the stand that the impugned transfer order only speaks about his transfer being made in the organization interest, without the same not being substantiated by any bona fide reasons or in the interest of public. Stop. Therefore, the impugned transfer order is only a result of colorable exercise of power for collateral purposes by the respondent authorities, and the same should be interfered with by this court, or else serious injustice would be caused to the petitioner. The learned counsel also submits that due to the manner in which the impugned transfer order was passed, the petitioner did not have enough time to incorporate the representation which he had submitted to the Director General of Border Roads. And therefore, pending consideration of his representation, some protection should be given to the petitioner. Citing the case of B. Varadha Rao Supra, the learned counsel submits that there is no dispute to the fact that transfer is an incident of service, and the appointing authority has wide discretion in the matter of transfer. and that the government is the best judge to decide how to distribute and utilize the services of its employees. But such exercise should be done with honesty, bona fide, and reasonably. Stop. If such exercise is based on extraneous considerations or for achieving an alien purpose or an oblique motive, comma, it would amount to malified and tolerable exercise of power. Stop. Therefore, frequent transfer without sufficient reasons to justify such transfers cannot but be held to be malified. It is true that the impugned transfer order does not provide in detail as to why such transfer has been done, except for stating that the posting has been approved in the organizational interest. Stop. However, at the same time, it cannot be said that the transfer order, at the face of it, appears to be a colorable exercise of power in view of sufficient reasons to justify such transfer not being mentioned. To stop. Transfer orders in general do not contain all the materials and reasons as to why such transfer has been effected. In anticipation that party concerned may eventually avail for remedies by filing appropriate application before the court. Stop. The instant impugned transfer order, therefore, having not mentioned the detail and reasons for making such transfer, this court is unable to. It would not be safe to presume that the exercise has been carried out with malified intent. Stop. This court is also not unmindful of the fact that, as pleaded by the petitioner, his prospect of future promotion would be jeopardized if he is moved from the present place of posting, which is a command post. Stop. However, as already observed herein above, and particularly taking note of the wide discretion that the competent authority has over the employees, in respect of transfer and posting. This court is not inclined to interfere with the impugned transfer order. The petitioner contends that, before that you write, at the same time, taking note of the contention of the petitioner that a representation has been sent to the Director General of Border Roads, bracket respondent number 2. It would be incumbent upon the state authority to take note of the nature of grievance projected by the petitioner, that is frequent transfer, and his future prospect for promotion if he is not posted in a command post in particular. Such representation, the representation so filed, be disposed of as expeditiously as possible and at any rate within a period of any time prescribed, 7 days.
No problem. Lordship may indicate.
Sorry,
Lordship may indicate any date, Lordship, we have no problem.
7 days from the date of receipt of a certified copy of this order. Mr. Bora, where is your representation at the moment?
Yes, it is at a command level, commander task force,
No,
Respondent
where did you submit?
commander, respondent 5.
Respondent number
It will
5.
go through proper channel.
Mm.
Commander, then chief engineer, then ADGBR, then DGBR.
According to the petitioner, he had submitted his representation before the respondent number,
Through proper channel, Your Lordship.
respondent number 5. To the respondent number 2 through proper channel. To stop the respondent authorities concerned shall ensure that the representation reaches the respondent number 2 in order to carry out the directions as provided herein above. It is also made clear that I think not required. That'll be all.
Lordship, my career prospects are ruined now, Your Lordship. I'll not be having any command experience. I'll not be eligible for promotion to the next higher rank of superintendent engineer. Your Lordship may kindly observe that when I am considered for the next higher rank next year, Your Lordship, because I'm 54 now, I am under threshold age and I'll be considered for promotion, Your Lordship.
I've made that observation.
Your Lordship may kindly make it clear, Your Lordship, that particular criteria may be ignored, Your Lordship. When I'll be considered. Your Lordship, because, Your Lordship,
That is an
that will-
extended version of the writ petition.
Lordship.
Your Lordship, otherwise this whole, my career is ruined otherwise, Your Lordship. I'll not be considered for promotion. This is sort of a punishment transfer, Your Lordship.
That cannot be, Lordship.
Because my career is ruined otherwise. I'll not be eligible for promotion. I don't have any command experience, Your Lordship.
I can't make, I already made the observation regarding your apprehension about your command posting and your future promotion. That will take care of it.
That is a basically.
No, beyond that, we cannot go to the guidelines and say that ignore these guidelines for the petitioner. Can we do that? I don't
Your
think
Lordship,
so.
under 226, Your Lordship, white forest, Your Lordship. Otherwise, my
That's not
career.
even
is
your
ruined,
prayer
Lordship.
in the first place.
My career is otherwise ruined, Your Lordship.
You can't say that. They might reconsider it.
It cannot happen. The recruitment rules say so, Your Lordship. I have to have 2 years of command experience. Otherwise.
No,
I
no.
won't be considered.
Your posting, they may reconsider it. I have given that direction to reconsider.
Shit, that will, in my humble opinion, Your Lordship, it will not happen.
Yes, next please.
My lord, I am praying for some time to file the counter in the IA, my lord. They filed a stay vacation application and I am praying for some time to file our counter, my lord.
How long should you take your counter? You were given chance last time also.
Instructions was given, but since the petitioner was scattered, so instructions I received late, my lord. This is the second time it has been listed.
What is to be modified?
Initially, the honorable court has given to appoint them respondent number 6 to 7 as ICU technician. Thereafter, on 21/6/24, this order was vacated.
I think this or which order was vacated?
Earlier interim order, Lordship.
Huh?
Earlier interim order.
My lord, what happened, my lord, this private respondent number 6 to 10.
Just show me the order which is supposed to be vacated.
Order it, my lord.
Is it annexed to the IA?
Next, my lord, I am for the respondent number 6, my lord. We have filed also in one IA for the vacating.
No, somebody tell me what is to be vacated.
My lord,
Somebody-
It's defective, they have not annexed the order which is sought to be vacated.
I was searching for the order which is sought to be vacated. It's not available anywhere. Now, let us see in the writ petition, which order you want to vacate. Dated?
Order dated 21/6/2024.
21/6.
2024.
There is no 21/6. 24.
Yes, ma'am.
Yes, madam.
Okay, 21/6.
Yes.
Okay,
Well,
how much time?
my lord, being respondent number 6 in the repetition, my lord, we have also filed an IA, my lord. It is not listed with this, my lord, repetition today, my lord. In that IA, we have annexed the, my lord, the order which needs to be vacated, my lord.
When did you file the IA?
Well, on 5/12, my lord.
Respond number 6.
Respondent number 6 of the repetition, my lord. And in
Okay,
the- of
Mr.
this IA
K.R. Patgiri? No, sorry, Mr.
J. Patwari.
J. Patwari, learned counsel for the
Writ petitioner opposite party.
writ petitioner / opposite party prays for how much time?
Next time.
2 weeks time to file objection to the IA. Prayers allowed. List the matter again. After 2 weeks, along with the IA said to have been filed by respondent number 6.
Lordship, kindly dated, fix a date, Lordship.
Deeply.
My lord, kindly a date. and Fix, my lord. If convenient, my lord, any date, my lord. In the first week of January, my lord.
Okay, instead of 2 weeks, you write list on 9th
9th of January.
9th of January.
I'm deeply upset.
May it please your lordship.
Yes.
My lord, I am appearing on behalf of respondent 2 and 3.
Why is it listed for orders today?
Lord, my lord may kindly peruse the office note dated 10/12/24.
You have for respondent number?
2 and 3.
Where is your wakalat nama? You have not filed your wakalat nama, that's why. Office note dated 10/12/2024 indicates that although an affidavit of opposition has been filed by respondent numbers 2 and 3, but there is no wakalatnama filed by the appointed counsel. Mr.
Ereka.
A. Deka, learned counsel for respondent numbers 2 and 3 submits that he will be filing the same within
Within a week.
a week's time.
Obliged.
Mr. C.K.S. Barua, learned counsel appears for respondent number 1. In the beginning, you write, none appears for the petitioner.
But in these matters, we were understanding that the matters required to be fully heard. Or what has happened is there were two petitions filed by the writ petitioner.
Hmm.
One challenging the cancellation of his caste certificate, and the
Hmm.
other a disciplinary proceeding based on such cancellation. In both the cases, this honorable court had given a interim protection. In one, saying that the DP will not proceed, and on the other, it was said that on the
DP will
basis-
proceed, but don't take final action.
and in the other, the interim protection was that no coercive action on the basis of the cancellation. Now, my lord, we were all in a concern that if this matter should be taken up in January and the matter is being finally heard, because stay vacation petition has been filed in one of the writ petitions. The other stay would again cover the petitioner because no coercive action would come out of that cancellation. So ultimately, my lord, if the matter is taken up,
Lordship may fix a pleading is complete.
You have a date in mind?
Lordship in after vacation.
yes, ma'am.
As agreed to by the parties, list the matter for admission hearing on 23rd January 2025. Thursday.
Not on 20th, on 28th, Lordship. 20th, other matters has been fixed.
All right, 28th.
28th.
Obliged.
May I please, your lordship?
Yes.
Lordship, in this matter, in the writ petition, I am challenging a remark sheet of the medical reassessment that was conducted on me, which says that I am a person of lot of benchmark disability, due to which my appointment was rejected. I was not given appointment. In this IA, pending the writ petition, I am praying that the post may be kept vacant.
My lord, the first thing is that already we have filed affidavit. If they are not, my lord, if they want to file reply, my lord, then fine. Otherwise, my lord, take this, ask for final disposal. My lord, in between, my lord, keeping a post vacant, my lord, that will create a havoc, my lord.
Junior inspector,
Duty inspector, lordship.
what is your right to the post?
Lordship.
What is your right to the post?
Lordship, I was qualified for appointment, subject to clearing the medical reassessment. In medical reassessment, it has been assessed that
No, whether there has been any such kind of process of selection.
yes, this is the selection process that has been.
No, being qualified to be promoted is one thing, but was there any process started already wherein you have been found to be?
Yes, pursuant to the advertisement,
Ah.
I appeared in the written examination, I cleared it.
Okay,
Then I appeared in the skill test, I cleared it.
okay.
After which I was declared to be qualified for appointment in these two posts, any
Then?
one of these two posts.
Then what happened?
After that, since I was a person of benchmark disability, I claimed to be a benchmark disability.
Okay,
Person with benchmark disability, that is 40% disability.
okay.
Since I claim to be a person of benchmark disability,
So some concession is there. Oh,
yes, the post is reserved for person with benchmark disability.
I see.
So the respondents conducted a medical reassessment
Hmm.
to assure that I am a person with benchmark disability.
Hmm.
In that reassessment, it came out that my percentage of disability is 23%,
Not 40.
not 40. And I'm challenging that in the writ petition. I'm challenging that no, there has been an error on the part of the medical board, which says that I am 23%.
Hmm.
And pending that, now your lordship.
How many
fresh-
vacancies are there in all
As of now, 3 vacancies are there
for benchmark disability?
for the first category, wherein the post of junior inspector is there. And for the second one, there are 48 posts vacant.
What do you mean second one?
There are 2 posts, your lordship. One is the post of junior inspector / auditor under the cooperation department. Herein 3 posts are lying vacant as of now. And in the Panchayat and Rural Development Department, 48 posts are lying vacant as of now. Now, lordship, the mechanism is that once I am qualified for appointment, that post is for me. If I clarify the medical reassessment, I am appointed. Now, since I could not qualify, I could not clarify the medical reassessment. So that post is lying vacant as of now. But pursuant to the fresh advertisement, written examination has been held.
Oh, fresh
Fresh
advertisement.
advertisement, written examination was held on 29th of September 2024.
Yeah.
And the results may be declared anytime. So fresh candidates will come into that post. So there will be multiplicity of litigation, and if someone is elected, someone is appointed in that post, my entire case goes. It becomes infructuous. So that is the only reason I'm praying for keeping the post vacant. And the writ petition at this stage can't be disposed of because the reply from the health department is awaited.
affidavit has not been filed from the health department. That's the most important thing.
Yes, Mr. Dhar, have you filed objection to this IA, by the way? You have not filed.
Lordship, here,
Oh, Mr. Chaudhary.
Lordship, here, I'm appearing for the state level recruitment commission.
Hmm.
Lordship, under the commission, the proposal for, in respect of the vacancy is received from the various department. Thereafter, the advertisement is issued. And after the written test, Lordship, all those person who got the qualification mark as per the grade pay and everything, Lordship, it is put into a software in the presence of the eminent person with the act provides, Lordship. Thereafter, as per their marks, they are the software gives them in place them in their various vacancies. And Lordship, now the petitioner that is claiming that only these two posts may be kept vacant, Lordship, that cannot be done because it's the software places the person in the various vacancy as per their marks obtained in the written and skill test. And here the petitioner applied for two posts, one having bachelor degree and one bachelor degree with computer diploma.
One post is regarding junior inspector, auditor, cooperative society.
Lordship, there is no specific application for a particular post. For all the grade 3 posts of various departments are accumulated. Lordship, they have to only apply online. And on the basis of the documents that they submit on the online portal, they are called for the written test, and on qualification, they are sent to the next level of skill test. And subsequently, the commission makes the recommendation, and thereafter, it is again subject to verification of the documents as per the service rule of the various department to which the candidates are allotted the post.
Okay, regarding the disability certificate, who examines that?
That is under the direction of the government. The re-verification was done by the health
See,
department.
at the initial stage, they produce a certificate, isn't it?
Yes, Lordship.
And that certificate is accepted for them to participate.
Yes,
But later on, again, it is
Lordship, because on the basis of the certificate, either on the education qualification or the disability certificate, they are taken to be presumed to be valid, and accordingly they are called for the written test and next level.
who does the scrutiny later on?
Later on, the various department to whom the petitioners have been allotted the post,
They do the scrutiny.
they do the further verification, but the medical re-verification was done as per the direction of the government by the health department.
Where is that? Where's that direction?
Lordship, there is an OM, Lordship, issued by the personnel department.
What does it say?
It states that after selection and recommendation, they those disabled person, they will be subject to re-verification.
That OM is followed.
Yes,
So that re-verification is done as per the OM.
yes, ma'am.
Okay.
On the part of the commission, Lordship, we only recommend on the basis of the marks obtained in the.
See, that is the process. Now, the apprehension is that since there's a new process which has been initiated, since the petitioner was not selected because of some disparity in the percentage of the disability.
Yes, ma'am.
So now new process has been initiated. He apprehends that if the new process is finalized and ultimately if he succeeds in the writ petition,
Lordship,
he'll have some.
on the first day of moving the case, this court directed that his claim will be subject to outcome of the case.
His claim
Yes.
or a
Lordship.
promotion or
His
appointment.
claim for appointment, Lordship. On the
No.
initial first date, Lordship, court didn't.
No, his claim for appointment will be subject to outcome. How can that be?
Lordship, that your lordship will find at page 34 of the IA.
Okay.
Third last paragraph from
The
bottom.
claim of the petitioner shall be subject to the outcome of the writ petition.
Already, Lordship,
Lordship, if the
there
post
is a-
is filled up, there will be no vacancy left. That is my apprehension.
And the vacancy matrix was released on 13th of August 2024. After that, I filed the IA.
Now, what is lacking in the writ petition now?
In the writ petition, we are awaiting the affidavit from the health department.
Health department has not filed affidavit.
No, Your Lordship. That's the most important thing.
Is it the health department who has done the review, medical?
The medical board
Yes,
is, the health department represents the medical board. The medical board is of Guwahati Medical College Hospital, GMCH.
They are party here?
They are party here. Respondent number 13.
Who's appearing for that? GMC?
It was carried out on the basis of the OM, Lordship. I have that OM.
No, you are for the GMC?
Yes, Lordship. Guwahati Medical College and Hospital.
Hmm.
Since there was a direction, Lordship, we have conducted the
And the certificate was issued by whom? Your disability?
My disability certificate.
joint director, Lordship.
Health?
Yes, Lordship.
Yes, Your Lordship, health department.
So the certificate of the joint director of health department is pitted against the certificate issued by the GMCH,
Yes.
Medical board.
medical board.
Yes.
Ah, that's what.
Considered under that.
How can there be two different opinions like that?
Lordship, as per this OM, Lordship, clause 5 of this OM, Lordship.
This is not disputed, I think, by the petitioner also.
No, Lordship.
No.
So clause 5, Lordship, it states that we can do the re-verification, Lordship.
The
their
reassessment process
appointment-
is not under challenge by,
So Lordship, we have only done the reassessment part, Lordship.
Correct. Reassessment has two different conclusion. One is 40%, one is less than 40.
Yes, Lordship.
And it is issued by joint director and one is by the medical board. Medical board also from the health.
Yes, Lordship. But joint director issued it, Lordship, earlier, Lordship, prior to the
What kind of disability is that?
hearing disability.
Hearing.
Hearing
So
disability.
Lordship, there might be variations, Lordship. It might go up, it might go down, Lordship. That's why, Lordship, once we have found it to be 23, Lordship, now. On reassessment, Lordship.
I'm challenging the finding of the medical board which says that it is 23%. I claim to be of 57.1%. And the basis of my claim, Your Lordship, is another medical BERA test that I conducted at GMCH itself in November 2023. From where it can be inferred that my percentage of disability is 57%.
Where is the medical board's finding?
Lordship, the remark sheet, the IA at page number 20, page number 30, Your Lordship.
No, you have
In
not
the-
challenged that in the writ petition.
Yes, it is on the challenge in the writ petition.
Where? Which page number? That's what I'm
In
asking.
the writ petition, Your Lordship.
Yes.
Lordship, it is page number 101. It is annexed as 101, and in my prayer, I have specifically mentioned to set aside the first prayer at page number 20.
One zero one.
101 is the annexure, Your Lordship, the
No,
medical board, the remark sheet.
the finding of the board.
Yes.
That is what I'm asking you.
Lordship, page number 101, serial number 218 of the writ petition, Your Lordship, writ petition number 2869, Your Lordship.
23%.
Yes, Your Lordship. It is coming as 23%. I'm challenging this.
I copy an item.
There are so many other people, isn't it?
Yes, Your Lordship. 101. 101 is the writ petition. Writ petition. WPC 287.
This one.
So the new selection, when is it due to be finalized?
Lordship, selection, Lordship, my colleague will say, Lordship, because we have only done the reassessment part, Lordship. Selection of fields.
Lordship, the new selection, again, proposal has been received. the written test has been held during the month of September. Now, Lordship, for the purpose of declaring the result, it is under process, Lordship.
Declaration of result.
Yes, Lord.
So what will happen to the case of the petitioner then, if you declare the result?
Lordship,
Supposing he succeeds, then
Lordship, then we'll have to accommodate
how?
if he succeeds.
How? Because but in the meantime, if you have completed the process and you have chosen other candidates and the posts are
Lordship,
filled up,
not only him, there are other person who have also challenged the medical reassessment, basically. And Lordship, in
and what is the order passed in those cases?
Lordship, in some of the
Any interim order?
no, subject to outcome, or in some cases there are no subject to outcome also. And in the provisional list, Lordship, it was specifically stated that their further appointment will be subject to the re-verification. And they, without any objection, they participated in the re-verification.
But that's okay. He doesn't have any choice. He'll have to participate. But now he's challenging that re-verification, the finding of the medical board. Only thing is that his interest has to be protected.
Because Lordship, on the first day, this court didn't find anything to give any interim order. Only that subject to outcome was given.
All right, you do one thing, you file whatever objection you have to file. We'll take it up again after a week.
Yes,
Mr. Adhar. And who? You file an objection. We'll list again next Thursday for consideration of the. All right, Mr. Counsel.
The Mayor, Lordship may take it up for final disposal immediately on reopening of the case vacation. Lordship, because if any order is passed, Lordship, it will have an impact on the selection process, because there are other person also who have on the same ground they have challenged.
That can be done subject to the health department filing their affidavit. Can you file affidavit? When are you going to file?
Lordship is fixing it on 19th.
Yes, 19th.
Yes, Lordship. We'll try, Lordship.
As paid for by the learned counsels for the respondents. A week's time is granted for filing objection to the IA. Respondents are also the health department shall also file the counter affidavit in the main writ petition, so that an attempt can be made to dispose of the entire writ petition by the next date. List again on 19th.
Highly
Obliged, Your Lordship.
My lord, with apologies, my lord, item number 17 and 18. The interim orders, my lord, they've been fixed on the January, my lord. There was an interim order in the case.
Okay, 17, 18. Interim order passed earlier shall continue till the next date of listing.
Deeply
My
obliged.
lord, in item number 16, my lord, my sister is appearing for the petitioner. But I am appearing for a department, my lord. But in the office note 10-12, it has been shown that we have to file a number. But our number is not prepared, I think, my lord. We can file our memorandum of appearance before the filing section. She had to file the record number.
7.
16, my lord. Item number 16.
No, which respondent?
My lord, for 2 and 3, my lord.
What did I say? Okay, who's 2 and 3?
I'm paying for the petition. I've been engaged recently, my lord.
Oh, respondent number 2 and 3.
But I am appearing.
Who is that?
This is the director and the superintendent of ITI, my lord. But I'm not standing out here. But I'll file the memorandum of appearance, my lord.
Okay.
Instead of record number.
Instead of Vakala number, you said you put memorandum of appearance.
No, no.
Counsel for the respondent numbers 2 and 3 may file memorandum of appearance in lieu of wakalatnama. Right.
My lord, a date may be fixed in the month of February, my lord. January, I have some problem. my lord. Retired pensioner.
Indian even pay. A week's time. Okay, then we list again on 5th of February 2025. 5 minutes after.
This is an IA seeking a modification of the order of this honorable court dated 26/7/2023.
Page?
That is 17 of the IA lordship.
Yes, what kind of modification?
Lordship, the modification that we see if lordship looks at third paragraph at page 18 of the order, lordship, that is the order which says that the original order of the writ petition made a categorical direction to appoint the petitioner in grade 3 post. But lordship, the original order was to consider the request, the application of the petitioner, lordship. And accordingly, the petition was considered by the two speaking orders, lordship. One 14.
Where is this order dated 1812?
That is at page 13 of the IA, lordship. The operative part is, lordship, para 6.
Request. So he was supposed to consider
Lordship.
appointment to the grade 3 post.
Lordship.
That has been done.
That has been done, lord.
Then what is the result?
Result is that
Cannot be appointed.
he cannot be appointed because his original application when it was submitted, he was only HSLC pass, 10 standard pass, and to be appointed to grade 3, he would have to be 12 standard pass.
Okay, now there was a order for personal appearance
That was dispensed with, lordship.
dispensed with.
Lordship.
And today you want modification of this order.
Lordship.
May I submit it?
Yes.
So prior to filing this IA, lordship may come to their affidavit in opposition, they have filed the main lordship contempt petition. First, because lordship served to me in June 2023, lordship, they have filed an affidavit in opposition. First affidavit in opposition, lordship.
See, before that, why don't we just give you some time? You want to file objection?
Thing is that, lordship, they are just filing one after another IA, not trying to compare with the others on all four. This is the case, lordship.
Okay.
First, lordship, they have filed their affidavit in opposition. It was in June, lordship, 2023.
IA in the contempt.
No, in contempt petition,
This-
lordship, they have filed affidavit in opposition.
Today's IA is in the contempt.
Lordship. It is in the-
I'm just trying to lordship, draw your lordship attention, the conduct lordship they are lordship doing lordship the act. First, lordship, they have filed an affidavit in opposition in the main contempt petition. It was filed lordship in June 2023. The present lordship, the applicant.
Where's the affidavit?
Lordship affidavit in opposition, they have filed it in June
It
2020.
starts at page 41, lordship, running.
So after filing lordship this affidavit,
41.
there is shown running page 41, lordship, I'm not sure lordship whether matching with the court records or not.
Yes.
Lordship.
Affidavit of position.
Affidavit in opposition, lordship. Yes, lordship will find the paragraph number 4 of their affidavit in opposition.
Yes.
The opponent begs to state that in pursuance of the Honorable High Court's order dated 18/12/18, government letter number so and so, requested the PCCF and head of forest force Assam to furnish details and accordingly report was submitted to the government. File letter number so and so dated 14/5/19, stating that the petitioner was appointed in Getchipur as plantation mali as per recommendation of the meeting date of 1/4/15 of the state level committee. The state level committee, after due deliberation, recommended the name of the petitioner for appointment in Getchipur post against the vacancy year of 1997. By office order dated 5/5/7 dated 15/7/15. Be it stated herein that at the time of submission of application for appointment on competition ground, the petitioner had passed SSLC examination. Initially, Lordship, they have rejected my prayer. Then, Lordship, after passing their affidavit in opposition, this honorable court take up the matter on Lordship on 26/7/2023. Lordship will find the order dated 26/7/2023. After passing their affidavit in opposition, Lordship, this order was passed. Order dated 26/7/23 Lordship. Lordship will, the relevant paragraph, Lordship, just I am reading. The paragraph number, it will be Lordship, third paragraph, after going to the order dated.
No, this we have already read.
Lordship, yes. So,
What do you want to say by this paragraph 4? Which
no,
you just,
but also, accordingly, their same submission, they are also stating in the I also, that this application cannot be considered because at the time of application, he was only HSLC pass, so grade 3 post cannot be given to him.
otherwise, what is the qualification required?
At the time of 1997, since application was of 1997, at that time, Lordship, HS 10 standard was the Lordship minimum qualification.
For grade 3 post?
Yes. So that has, they have Lordship not considered at all. Now,
Lordship, for grade 3, it's 12 standard.
it was recent, Lordship, not in 1997.
No, in the year 1997. What was the position in 1997?
It was the same, Lordship.
No, Lordship.
HSLC.
Yes, Lordship.
HSLC, if you agree, then he has passed HSLC.
No, I mean, Lordship, +2 was the requirement for grade 3.
Let them show the notification, Lordship.
Higher second.
Let them show the Lordship, government notification if there is there. After Lordship.
Why don't you also show 1997? This is the position.
Lordship, for grade 4 category, only class 6 was there. Class 6, grade 4. And grade 3 Lordship, yes.
We are concerned with grade 3.
Grade 3 is Lordship.
You are already in grade 4.
I've been appointed in grade 4.
Exactly. So you are already in grade 4. No need to open that. You say that you should be considered against grade 3.
Because
They say that you are only HSLC. So that's why you cannot be considered.
In the main contempt petition, I have annexed all those documents. They have Lordship approved. The government has approved my application for completion of grade 3 post. How Lordship they have approved? Because at that time, Lordship, only class 10 was the minimum.
Where is that? Show me.
Lordship, may come to main contempt petition.
Page number?
Page number, Lordship, 12.
12.
Yes. It was issued by Under Secretary Government of Assam to the PCCF, that is present applicant, Lordship. Inviting a reference to your letter quoted above, I am direct to say that proposal for appointment on compassionate ground in respect of Sri Ajay Kumar Majumdar, son of late so-and-so, ex-Forester 1, may be considered against grade 3 post.
Just a minute. You're reading from which page?
Page 12 of my contempt petition.
12.
Yes.
Okay, yes.
Yes. Maybe, wherefore, appointment on compassionate ground in respect of Sri Ajay Kumar Majumdar, son of late Arun Kumar Majumdar, ex-Forester 1, may be considered against grade 3 posts, subject to the observation of the existing rules and for the purpose including maintenance of roster system. So also only they were directed to see the roster, whether his recommendation is against the roster of compassion appointment.
No, subject to observation of existing rules.
Yes, existing rules is lost at the time for grade 3 post, class 10 standard was there.
Where is that?
That notification was I have not annexed in contempt petition. Then
You have to annex it.
Then Lordship will also see.
You must annex that.
No, Lordship, because it was not disputed, Lordship, now they are disputing the fact. Because after.
Okay, where is the order which has not been complied with?
Lordship.
Page 18.
Yes. Page, Lordship, 18 is the relevant, Lordship. 19 is the.
Starts from page 18.
Lordship.
What is the order date?
Order dated, Lordship.
18, 12, 18.
18,
Yes,
yes,
it starts from page 18.
page 18, Lordship. Heard a sir of Learned Council, petitioner heard Mr. J. Kakoti, Learned Council on behalf of the Mazumdar Learned Standing Council for the Forest Department. In this petition, the petitioner's father was earlier serving as a forester one who died while in service on 16/1/1997. After petitioner submitted an application for appointment under the die in harness scheme in August 1997. Thereafter, his application was forwarded for appointment on compassionate ground. It seems the respondent number 3 recommended the appointment of the petitioner up to a grade 3 post on account of vacancy existing at the relevant time filed letter dated so and so addressed to the respondent number 1. Thereafter, the office of respondent number 1 intimated the office of the respondent number 3 to consider the appointment of the petitioner to a grade 3 post subject to observation of existing rules for the purpose as indicated in the letter dated 23/7/1998, pursuant to which the respondent number 3 wrote to the additional forest officer respondent number 6 for appointment to a grade 3 post on recommendation on compassionate ground, as the said proposal already approved by the state government. The respondent number 3 thereafter wrote to the respondent number 6 on 2/2/1999, informing the aforesaid government approval. Respondent number 6 accordingly in turn wrote to the respondent number 5 for appointment of the petitioner on compassionate ground against grade 3 post. As no action was taken, the petitioner approached this court by filing writ petition number so and so, which was disposed of by this honorable court on 29/11/2022, directing the respondent number 6, namely Divisional First Officer Dhubri Division, to consider the case of the petitioner for appointment on compassionate ground to any grade 3 post in terms of the relevant government policy. However, the authorities insist of appointing the petitioner to a grade 3 post, appointed him in grade 4 post filed letter dated 15/7/15. Being agreed, the petitioner has approached the authorities for appointment to a grade 3 post. In this regards, the petitioner had submitted several representations, including on 18/12/17. However, the authorities have not responded to his plea for appointment to a grade 3 post. Considering the above, this court is of the view that present petition can be disposed of with a direction to the respondent authorities to consider the request of the petitioner for appointment to a grade 3 post in terms of earlier proposal made by the government as referred above, and also to directed by this court in the said requisition, which exercise shall be undertaken by the authorities within a period of 3 weeks from the date of receipt of the certified copies of the order. Learned Counsel for the petitioner submitted that many others who were appointed along with the petitioner to grade 4 post have been subsequently appointed to a grade 3 post. Therefore, the authorities shall keep this aspect in mind also while considering the case of the petitioner. So, on the approval made in the year 1999, his application for completion in grade 3 post was lordship directed to be considered. So, lordship, they are just now that order they have not challenged lordship, neither in appeal nor in review lordship they have come. After filing this contempt petition lordship in 19, they have filed their affidavit in 2023. And after considering their affidavit lordship, this honorable court filed order dated 26/7/23, categorically held that there is a specific order to appoint this petitioner in grade 3 post. Lordship will kindly see the order dated 26/7/23.
I've seen it, Mr.
Yes,
Counsel.
lordship. So after no,
You just answer the query of the court, okay?
yes, lordship.
Now, you say that at the year 1997,
Yes,
when you were approved, in fact, 98,
lordship.
you were approved for appointment to the grade 3 post.
Grade 3.
What is the criteria?
No, basic in professional ground lordship.
What is the educational qualification?
Lordship, I have to produce if lordship necessary, I will produce in the next the requisite lordship notification or lordship any rules. For the lordship for grade 3 post, SSLC or 12 standard was necessary.
Because the recommendation made by the PCCF, it is clearly stated that you have passed HSLC.
That is true. I am not denying lordship.
Just listen. In the year 1996, you have passed HSLC.
Yes,
Recommended to the government.
lordship.
Now, the government also in their letter dated 23 July 1998 says that, yes, he may be considered against any grade 3 post.
Grade 3 post.
Correct.
Lordship.
And the court also said that you consider him as,
Grade
instead
3
of grade 4, you consider him as grade 3 post.
Lordship.
But now, although this is a contempt petition,
Lordship.
but for clarity, what was the actual position in 1998? If you can inform the court.
Lordship, let
And
me
that is one thing. Another thing is, what is the order which you say that you have complied with? By which order?
Two speaking orders, lordship, that.
Two speaking order. One is not enough.
After passing the order,
Because
this honorable
there
court
was an interim order. in
Yes,
this
what is the
contempt
speaking order dated?
In page 19 of the IA, Lordship. That is the first speaking order.
Forget about your IA. IA is for modifying the order. You had submitted something to the court last time.
Yes.
And the
Yes.
court had asked you to file it by way of an affidavit. You have not done it.
That is for under vetting, Lordship, which is why we
What is under vetting?
that affidavit.
What is there to vet?
It takes time.
Supposing this is the speaking order,
Yes.
you are supposed to just enclose it and file it. The authority will again vet his own order. It's
We'll
ridiculous.
file it by next week.
Last 4 years, Lordship, they are just passing speaking order, speaking order.
See, anyway, what is the speaking order dated?
The recent one is Lordship 2/4/2024.
Okay, what does it say?
It is like an appellate order of this noble court, Lordship, not a speaking order.
It says that because at the time of his application, he was HSLC pass. He could not have been appointed to grade 3 post. That is what it says, Lordship. Plus,
So what kind of order is this? RP Singh, IFS. Is he a party?
he has superannuated.
Superannuated. Okay, what is the other order? One is 2/4/24 and the other one?
There was an earlier one, 14/8/2023, Lordship.
Where is that? Have you submitted?
That has been annexed in the IA, Lord.
Somehow we have to see your IA now. Page?
19, starts at 19, Lord.
What is the conclusion?
Same conclusion, Lord.
No, what is the justification? What is the reason?
Uh, Same, Lordship, because he was not qualified at that time to hold.
Where is it? Which part of this order?
That Lordship will find at page 22, para 2, D, Lordship.
The time of his application, he was HSLC.
Lordship.
And his application was on which year? 98. 97 or 98?
It was 98.
98.
If only got 97.
97.
Then ultimately you were appointed.
Grade 4.
Sorry,
Grade 4 post, Lordship.
when was he appointed as grade 4?
15, Lordship, 2015.
2015.
2015.
Lordship.
After the first round of writ petition, his case was considered, and because for
First
grade
round of
3
case
he
of-
was not qualified. Initially, the processing was for grade 3 because his father was holding a grade 3 for.
That is wrong submission, Lordship. On the basis of educational qualification, it was recommended and approved by the government also, Lordship, in 1998.
First round was 6698 of 2002. Writ petition.
Yes, first equation.
First round.
Do you have the order?
Order copy, Lordship.
Order.
Read petition.
29, 29/11/2002.
In contempt petition, Lordship, I have annexed.
Yes,
Plus,
the order passed in the first round.
first round, Lord. Lordship will find starting page.
Page number
Page 13, Lordship, starting.
Uh,
And page
13.
15 is the relevant, Lordship.
15.
Lordship.
So this mentions grade 3, isn't it? But then he was appointed in grade 4. So that's why he came in the writ by filing second writ petition. Then see, second writ petition was taken up.
In Lordship, 12, 18, 12, 2018. Page 18, Lordship.
What was there was no affidavit of position.
Lordship, they have filed, Lordship. I have received a copy, Lordship.
No, in the other writ petition, the second writ petition,
Petition, Lordship.
they have not filed.
Okay. But they
But the
consider
court disposed of.
on their Lordship consideration.
So I think you just find out what is the criteria at that time,
At that time, Lordship, I will bring on.
and
the
we'll
table.
consider.
And let them also, Lordship,
Ah.
try if they have
We'll
the
also
rules,
try.
Lordship, of
Okay.
1998.
Court is not inclined to consider the IA.
Because
What modification? See,
That will
see,
be
if
required.
you want, you could have filed an appeal or whatever.
This is the
Because
second I, Lordship.
it
No,
was an
Lordship, this is
interim
the
order,
second I.
Lordship. That is why we had
Lordship,
Huh?
the modification that we are seeking, that is for an interim order in this contempt petition. Because Lordship, in our belief, it has traveled beyond the direction of the writ petition, Lordship.
No, what interim order you're seeking?
Uh,
Which interim order?
23, it is 26/7/2023, page 17 of the IA, Lordship.
this is the second I, Lordship. Same prayer, Lordship, second I. First I number is, Lordship, 2628. Lordship will see
Because in the first two rounds of writ petition, the direction was consideration, but somehow in this order, Lordship,
No. What modification are you seeking for?
that this part, Lordship,
Which part?
that the para 3,
After going through the order, this one.
yes, Lordship, that is the one. That,
Anyway, you produce. Please write down. It is the case of the petitioner that he should be appointed to a grade 3 post under the compassionate appointment scheme, since his father expired. His father died in harness. Stop. The respondents have otherwise appointed him to a grade 4 post. And by filing this contempt petition, the petitioner contends that the direction of this court to consider him for appointment to grade 3 post has been violated. Stop. On the other hand, the respondents contend that since the petitioner is only an HSLC pass, he can be appointed only to a grade 4 post. Next para, considering the above position, parties to produce the relevant criteria for considering the appointment to a grade 3 post, as and when the application had been submitted by the petitioner in the year 1998. List the matter again. When?
Lordship, immediately after opening.
My lord, he must also bring
Lordship,
on
I will try my
record,
best.
no, on record
Yes.
when he acquired the degree.
That is not necessary, Lordship.
No, no.
More from my part.
My lord, for adjudication of this, my lord.
Not
it's very-
necessary at all, Lordship. Not necessary at all.
Your document shows that he's HSLC pass. Why should we doubt that?
Of course, Lordship.
Only thing is that whether it is
They are just misleading the court, Lordship.
IA will remain. I'm not
I-
considering it.
I have no objection. That may be recorded, Lordship. Because two IA that cannot be filed. IA first IA that has been disposed of, Lordship.
I am not passing any order.
Yes,
That order will go in the contempt.
Lordship. Obliged.
Obliged.
What did I say? List the matter again. Huh? I didn't say, no?
May I please, my lord?
List the matter again. On 8/1/2025. Then in the IA also, right? List the matter again on 8/1/2025.
May I please, Your Lordship, my lord?
Yes.
My lord, here, my lord, the petitioner, my lord, this is participated in a selection process for the post of assistant accounts officer, my lord. And now, my lord, for 9 numbers of question, Lordship, it is evident from order dated 6/5/2024 by this honorable court. my
Which
lord.
item is this? Item 3.
Item 3, my lord. 6/5/2024, my lord. The honorable court, my lord, I challenge 9 number of questions. If I get the correct mark in respect to 9 number of questions, my lord, then I would have, my lord, be in the select list. So against this 9 number of questions, they have evaluated 5 numbers of questions, my lord. And as regard 4 numbers of question, 1 to 4, my lord, they file one affidavit, but they have failed to say what is the marks actually I.
Okay, that is why the detailed affidavit was required to be
Yes,
filed.
my lord.
Where is that affidavit?
My lord, we have to produce the records as well, my lord, from the Guwahati University.
Ah.
The department is communicating with them, my lord. We need some time to, my lord, for that.
How much time?
After the vacation, my lord, ensuing vacation, my lord.
My lord, matter is the whole matter, Lordship, may in that case fix a date, my lord, kindly, my lord.
We'll fix the date naturally.
Yes, my lord.
But tell me, when can you file it? We'll not just superficially fix a date.
Because already they availed of time. So 6, 8. On 8th January, kindly, my lord. And this is maybe the last operation because they have spelled out the reason for why they have 4 numbers of question answer marks they have not given in the earlier affidavit. They have already filed one affidavit earlier.
You are for the APDCL.
Yes, my lord, for APDCL.
You are supposed to produce the records also.
Yes, my lord.
Yes.
That's
Records is with whom?
with the Guwahati University, my lord.
Guwahati University.
APDCL only. They have conducted the.
We have
through-
conducted
through
an exam with
Guwahati University.
in collaboration with Guwahati University as well as APTEX, my lord.
APDCL.
Yes, my lord.
APDCL has to produce.
You must be having the records.
Yes.
No, my
That
lord.
has been recorded here also.
We'll produce the records, my lord.
See, it says that Mr. Deenat, Standing Counsel, APGCL, submits that since the records of the subject of selections are with the APDCL,
Mark.
the explanation as sought by this court could not be included in the said additional affidavit. Now you're saying it's with the.
Yes, my
And
lord.
in fact,
That is what I've been
subsequent, there
informed.
is subsequent order 2011, my lord. Subsequent order also.
No, I'm reading from 2011 only.
Yes, yes, para 5.
I'm reading from paragraph 3.
Correct, correct. No, let them avail one chance, if they cannot, my lord, on 8, my lord, matter may be fixed, because earlier they have already filed one affidavit, they say, if marks in respect 1 to 4 question given, then it will amount to, my lord, reviewing the select list.
Okay.
But, my lord, so far that query is concerned, this is already been answered by the Honorable Supreme Court. I will place that on the next day.
Please write, parties are represented by their respective councils. Stop at the outset, Mr.
B. Das, my lord.
B. Das, Learned Counsel, Learned Standing Counsel, APDCL submits that he needs some more time to file the detailed affidavit and to produce the relevant records in terms of the order dated 2011-2024. Stop. Mr. B.K. Das, Learned Counsel for the petitioner, submits that there is urgency in the matter and therefore a fixed date may be given. Mr. H.R. Das, Learned Counsel, appears for the. What is that? Learned Standing Counsel, APGCL, appears for respondent numbers 3 and 4. What is your submission?
We have filed we are not the conducting authority in this matter, Lordship.
They are the
Election
appointing
process has
authority.
been carried out by the APTCL in this matter, Lordship.
And submits that the APGCL is not the conducting authority of the examination. However, the APGCL has already filed their affidavit in opposition. Next para, considering the submissions made, let the matter be listed on
9th of January. Note of January. Then take your no problem. Okay. On 9th, my lord.
9th of January,
March.
2025.
No, it should be as a last opportunity, because earlier also, well, they took time for getting. As a last opportunity. There's 4th matter is getting delayed, my lord. Already they filed affidavit in 2021.
With the understanding that the AP
DCL.
You continue, no full stop. List again on so and so, with the understanding that the respondent APDCL shall file the additional affidavit and produce the record on that day
Obliged.
to enable the court to take up the matter for final consideration.
Yes, my lord. Obliged.
May I please, Your Lordship, madam, I am appearing for respondent number 3 in this case. So petitioner has also filed an IA in this case, alleging non-payment of certain amount. So in the month of November, some amount has been released to the petitioner. So to that effect, we need to file an additional affidavit.
What is the claim, Mr. Chalia?
My lord,
What is your case?
my case is not, I'm an employee under the organization my land friend is representing. And I was appointed in originally in 1994. Then subsequently declaration was made in 1998. And when I attained the age of 58, my lord, they passed an order asking me to retire from service. That I challenged, stating that the petitioner or the respondent is an organization, it is a cooperative under the central government, it is TRIPED. My lord, TRIPED is a cooperative society. Is a multi-state corporate.
Is your case that you have been retired before the
Age of 60.
age of 60?
Since the central government has opted for 60 years as a date of retirement of the employees. And although it is a central government organization, it is directly under the control of the Ministry of Tribal Affairs. They could not have retired me from service at 58. Court passed an order for off-stay, and accordingly, I continued in service and have retired finally in April at 60.
At 60.
60. I continue in Milan and on the basis of the court's order.
So what is the relief that you're claiming now? If you have completed, if you have served till 60, anything survives?
Now,
As per interim order, she continued up to 60.
Hmm.
And thereafter she returned.
Now what is left? You wanted to continue till 60, but by virtue of interim order, you have continued till 60.
continue. But they may, then already me there, I will say, look, since I have completed my up to 60 and with the court's order, I'll be entitled to all the pensionary benefits as available and service benefits available up to 60. If that is made, then otherwise I have to go on merit because this order in my humble submission, it is an arbitrary order of holding up 58. Because in the same organization, the persons who were appointed prior to 58, in 98, the central government has raised the age. And taking that, they have fixed.
So what is to be done today? You wanted to file something?
Well, we need to file an additional because there is an IA. In the IA, that petitioner made the allegation that we are not releasing certain amount to her. So in the month of November, some payment has been released. To that effect, we need to file an additional affidavit.
Mr. Chaliha, you want some time to file additional affidavit? In the month of which month?
In the month of November. On 27/11, some payment has been released.
That was in the IA. But the thing is that the main writ petition remains to be considered.
Yes. So both have to be considered together.
On the last occasion, it was stated that both the matters will be taken up together.
So now, in the month of November, some payment has been released. So that we need to bring in the record.
If the matter is heard and disposed of, that can be deducted or added, whatever.
That is true. Let us file the additional affidavit. Immediately after opening, that will be taken up.
Please write, parties are represented by the respective councils. Mr. Your good name?
S. Borali.
Mr. S. Borali, learned counsel, appearing for the
Respondent number 3.
respondent number 3 submits that although the petitioner has filed an IA for grant of annual increment and medical reimbursement,
This payment is for medical only.
according to the instructions received by him, some amount has been disbursed to the petitioner on
27/11.
27/11/2024. Stop. Therefore, he would like to bring the same on record by way of an affidavit. Next para. In respect of the main writ petition, it is seen that according to the petitioner, the employees under the organization TRIFED, TRIFED, has been segregated into two parts. For the purpose of superannuation. Stop. Employees who joined prior to 1/1/1998 would retire at the age of 60 years, while those who joined after 1198 would superannuate at the age of 58 years. Stop. Since the petitioner had joined after 1998. He has been kept in the second category for retirement at the age of 58 years. Stop. However, by virtue of an interim order, the petitioner has continued and has already reached the age of 60 years. Stop. Despite the same, in order to decide the entitlement of the petitioner as regards the pension and other related benefits, a decision on merit would be required. Stop. Since the learned counsel for the respondent number 3 seeks some time, how much time should you?
2 weeks time.
2 weeks time is granted for filing the additional affidavit. The matter be listed on
Review all days, any date.
23rd of January 2025. It's a Thursday. All right.
How long?
Yes, my lord, for the last occasion, my friend was on 27/11/2024. My friend was asked to take some instruction, my lord.
Yes, Lordship, I have received instruction. My lord may take it up this matter for final disposal.
That instruction may be, my lord, incorporated by way of filing an affidavit, my lord, so that I can reply, my lord.
Lordship, I have filed 2 affidavit already. This is a further instruction sought by this honorable court, and I have received the instruction. My lord may take up the matter for final disposal.
What is the instruction that's required?
What happened, my lord? The post of Loskar in the Kedar strength was directed to be produced. The Kedar strength is 322, and out of 322, my lord, 195 persons were working, and the other posts were lying vacant. That is 127 posts. And my lord, backlog strength is 70. Out of that, my lord, 5 was already working. My lord, 42 was still vacant out of 70. And my lord, if that 42 is deducted from my lord 127, post for general category remains my lord 85 posts. And that post could have been, my lord, filled up. My lord, my appointment was kept in abeyance because, my lord, it was apprehended that I was appointed against backlog vacant post. But, my lord, there were, my lord, 85 posts were lying vacant for the general category also. Open post, my lord. So, my lord,
Lordship, this is not the case actually. What happened, my lord? The petition, the post of law score is a direct recruitment. But in the year 2010, one DPC has considered 25 number of persons without any direct recruitment, and these posts are vacant for backlog vacancies. And after subsequently their appointment was kept in abeyance, and subsequently it was cancelled because the post of the law score is a direct recruitment post. It is not a promotional post, my lord. And that vacancy was filled up by another direct recruitment process, which was held in 2015. And the earlier instruction that was sought by this honorable court that I have brought it in a form of affidavit, it was the total strength in the year 2010. After that, the vacancies were filled up by direct recruitment. And there, they have retired as a master workers, and they are getting all the benefit as per open does, my lord. And they never challenge their kept in abeyance order. And after retirement, they have come before this honorable court for their benefits, my lord. Since it's a direct recruitment post, it cannot be given without any direct recruitment process, my lord. It is not a promotional post. It is
Petitioner was appointed as,
a master
was
worker.
engaged as muster role.
Shape.
Then thereafter, he was appointed as Laskar.
Without any recruitment process, direct recruitment.
What is that Laskar post?
It's a grade 4 post, my lord.
Grade 4 post.
For loss.
And as on being appointed as Laskar, you're getting what? Scale pay?
Yes.
You're getting scale pay.
Yes. For appointment as Laskar, my lord, he has to complete the crew training course. I have completed and my lord, if
There was no selection process?
selection process was initiated, I was selected, then only I was appointed.
Okay.
But their appointment was kept in abeyance immediately after 1 month because the
Because-
post of Laskar is a direct recruitment post, but their selection was no through direct recruitment.
Earlier, my lord, it was submitted.
Without any
my lord,
direct
those posts were
recruitment.
Backlog posts. That is why. my
Yes,
lord,
their backlog post. This is another aspect. These 25 posts are reserved for the backlog vacancies, my lord. And also the Laskar post is a direct recruitment post, my lord.
That is why, my lord, the phrase, my lord, instruction may be incorporated by way of
Yes,
filing
I
an
have received
affidavit, my lord, so that, my lord, I can reply, my lord. And
You filed it by what affidavit? Instructions she
on the next
received.
step, my lord, Lordship will take up the matter for final disposal.
And my lord may grant me some time, 2 weeks at least.
Ms. M.D. Bora, Learned Standing Counsel, Transport Department submits that he has received the instructions. On the queries raised by this court. Which order do we refer to? The instructions?
Received as per instruction.
27/11/2024, my lord.
No, before that. 22-1, I think.
22-1 lordship, yes, that I have filed
Says,
affidavit.
Ms. So-and-so shall the next date place the record of the cadre strength of the post of Laskar.
Regarding that lordship, I have filed affidavit.
This you have filed.
Yes.
Yes.
And
Then
after that, by the
27/11, my lord.
27/11, there's an order of this honorable court. I have taken time because I'll get further instruction.
queries raised by this court in terms of order dated 27/11/2024. In view of above, and as paid for 2 weeks time is granted to file the instructions received by way of an additional affidavit.
Lord.
List the matter again.
On 23rd, my lord.
January.
23rd January.
Okay, 23rd.
23rd,
After Bihu.
after Bihu vacation.
Yes, it's after B only. 23rd January.
Obliged, ma'am.
Obliged.
2025. How many cases left? 6, 7, 8, is it?
Obliged, lordship.
Yes, Mr. Mahant.
My lord, this matter relates to non-payment of higher grade pay to these petitioners who are emergency rescuers. Their claim is that there is a discrepancy in fixing the pay and the grade pay. Even that was not reconciled by the pay commission also. Then the anomaly committee recommended that yes, there is anomaly that should be reconciled. Department has been writing to the government that these disparities should be reconciled with financial implications, of course, there. But nothing has come forward. Therefore, the petitioners have ultimately come before this honorable court asking for that they are entitled to the higher grade pay, and there should be a separate set of recruitment rules for these persons who are working as emergency rescuer and who stands at a different level from the ordinary firefighting procedures. Now, the Home Department has filed an affidavit. Page 125. And
what are the petitioners?
they are the emergency rescuers.
Emergency-
SDRF, Lordship is aware about. They are working under they are controlled by the State Fire Service Department. And they are all the emergency rescuers, SDRF personnel, working under now they have, the department has been slightly renamed. They called it Director General of Director of Fire and Emergency Services, they call it. Under that, they are working. Now, my question is here, the finance is a party. Finance department is a party here, because ultimately it is pertaining to the grant of pay scale and it has some implications going to about few crores. Therefore, probably the matter has not been brought to the notice of the finance department, or they have just overlooked it. Notice was served. So, before we enter into the merit, let us ascertain whether finance department want to respond to it or not. Because ultimately,
Mr. Gogoi?
yes,
My lord, we need to file one affidavit. Can it be, my lord, after 4 weeks? I will file it now.
4 weeks is a too long time, my lord. Enough time was given, they were just sleeping over. What I find is 22 matter, 24 is ending. They have not responded, although whom has filed? The department has filed. They have supported, department has supported my case, that yes.
What is the pay scale that you are claiming?
We are claiming,
At par with some other, any
yes.
other post?
Disparity is, in case of reply. Lordship may see just one paragraph from the reply of the Home Department. They have, how they have taken it.
No, your claim, as per your prayer in their repetition, is that you should be given the scale of pay
Scale
at
of-
par
at
with
par.
those employees who are having the science background. HS pass. And the scale is
Persons with HS pass, they are getting more than we,
Ah.
the higher secondary pass with science. And our job is more riskier.
more risky. Risk is involved. So that is the reason why you.
Case, yes.
Finance, let them respond, Mr. Gogoi.
Give a date also.
You are for the respondent number 2, I think. Finance.
Yes, sir.
One is home. Home has given a reply?
They have filed the affidavit.
Okay.
Respondent.
They have admitted, department has admitted, yes. Whom has admitted it?
Please write, heard Mr. K.K. Mahanta, Lawrence Senior Counsel, assisted by Mr. K.A. Mahanta for the petitioners. Mr. B. Gogoi, learned Standing Counsel, Finance Department, at the outset submits that he may be given 4 weeks' time to file counter affidavit. Stop. Mr. Adhar, learned counsel appearing for the respondent, Home Department, submits that the Home Department has already filed a counter affidavit. Next para, in view of above, as prayed for, 4 weeks' time is granted to the Finance Department, with an understanding that the same will be filed within the given time. The matter shall now be listed on today's what?
Ninth, my lord.
Today's 12, isn't it? We'll list it after Bihu
Yes, let it be after Bihu.
Then 21st.
21st.
on 21st.
But
Yes.
before that, Lordship may
I will file that.
say that they should file it at least 1 week before, so that if necessary, you can respond. A weeks before, they should at least submit.
The Finance Department shall file the affidavit a week before the next date fixed, so that with a copy to the other side, so that the petitioner can respond to the same. Yes.
Yes, 21st. Obliged.
Lord, I'm appearing for Karbi Anglong Autonomous Council, Lordship. Lordship, here I am praying for 3 weeks time to file my affidavit, Lordship.
Lordship, last opportunity.
Last opportunity.
Lordship, here irrigation department is also required to file a affidavit. Lordship.
Who?
Irrigation department, Lordship. Because this matter pertains to regularization of service.
You are for which respondent?
I'm from Karbi Anglong Autonomous Council.
No, number
2346, Lordship.
2, 3, 4, and 6.
Lordship.
Your good name, Mr.
RS Ronghang, Lordship. Lordship, I'm appearing for 3, 4, and 6, Lordship. 3, 4, and 6. Lordship.
3, 4,
6, and 6.
6. And that's it.
Yes, Lordship.
3, 4, and 6.
Yes.
Then who's for the irrigation department? Anyone appeared earlier?
MS Neog used to appear.
Neog.
Neog.
He's not here, or she's not here today.
Lordship, she's the president.
DS Neog, isn't it?
Yes, Lordship. DS.
Hmm. Heard Miss R. Barwa, learned counsel for the petitioner, and Mr.
RS Ronghang.
RS
Ronghang.
spelling
RONGHANG.
RONGHANG, Ronghang. For the respondent numbers 3, 4, and 6. Stop at the outset. Learned counsel for the respondent numbers 3, 4, and 6. Prays for further 3 weeks time to file the counter affidavit. To stop, he submits that the irrigation department will also have to file their response in the matter. Stop. Today, no one appears for the irrigation department. It is seen that one Miss D.S. Neo, Standing Counsel Irrigation Department, had appeared on earlier occasion. Stop. Miss R. Barwa, Learned Counsel, submits that several opportunities have been granted to the respondents to file their response to the writ petition. And if time is to be given, same should be as a last chance. Next para, having regard to the fact that the writ petition was filed in 2023. No, cancel that. In view of above, let the matter, the respondents are granted further 3 weeks time to file their counter affidavit, with an understanding that the same will be filed by the next date. List the matter again. On 22/1/2025.
Deeply obliged.
This matter will pass out what time in Lordship? My senior is in foot number 11, Lordship.
Lordship, otherwise, Lordship, the record as directed on the last occasion is yet to be received by me, Lordship. So, Lordship, that is awaited. Lordship, can it be, Lordship, immediately after vacation, Lordship?
You were supposed to produce some record.
Yes, Lordship. On the last occasion, Lordship, I got the mark sheets and all, Lordship, but there was a direction to get the entire record, Lordship. That has not been placed till date, Lordship.
Have you conveyed otherwise?
Yes, Lordship, I have conveyed, Lordship.
Then before vacation, Lordship.
Lordship, before vacation, there are motion with immediately after vacation. On 6, Lordship.
So, Lordship,
heard the matter in length, Lordship. So
I've heard the matter in length, but if it's on 6th, I cannot hear the matter on 6th. Court will not be available. So this will not be treated as part heard then. Mr. D. Upamanya, learned standing counsel, Health Department, submits that he is yet to be furnished copy of the records which the court wanted to peruse in terms of the order dated 3/12/2024. To stop, he therefore seeks for further 3 weeks' time to produce the records.
well, it will matter when we keep part heard, Lordship.
I don't think that will be wise. This matter will get stuck. We don't know when the bench will be there available. But Mr. Upamanya, you should have got the records,
Yes,
isn't it?
Lordship.
Why?
But Lordship,
List the matter again on.
8 weeks को लेकर bench पर माथा गिरा। 8 weeks को लेकर bench पर माथा गिरा।
23rd of January 2025. Stop, the matter shall not be treated as a part heard.
23rd January.
Obliged.
In the
2 weeks time for
implement.
filing a for implement of party, case party, implement of necessary party.
As paid for by Mr.
Yeah, ma'am.
A. Ahmed, learned counsel for the petitioners. 2 weeks' time is granted to file an application
Implement.
for implement of necessary parties. As paid for. What is this?
Lordship, this is the information which I received from the directorate that the matter pertains to Director of Health Services FW, which they have not made a party. So Lordship,
Director Health Service made party, but
so that is the necessary party he will have to indicate.
So now he's praying for some time.
Yes,
Okay.
sir.
Highly obliged.
This matter could be taken up after some time, about a few weeks. There's some Supreme Court judgment we've been told, which covers the issue.
I also want to go for the judgment is said to be in my favor, Lordship. Immediately after vacation, Lordship.
As paid for by the parties, let the matter be listed again after the ensuing winter vacation on
Anytime in January, my lord, sir.
before or after BU.
अपना convenience will be there.
21st.
21st of January 2025.
Let's go.
Hmm.